Good afternoon. Welcome to the second session on acquired brain injury. On the last occasion, October the 28th, Joe Wesliak spoke to us on traumatic brain injury, social legal cognition. We sent out, it was a very helpful and insightful presentation. We sent out the recording. We hope everyone who attended received a copy of the recording, as well as his PowerPoint. If there are any issues, please reach out and we'll be happy to send you the information. I speak to you from Brampton, Ontario, and acknowledge the Anishinaabe, Huron-Wendat, Haudenosaunee, and Ojibwe Chippewa peoples, the land that is home to the Métis, and most recently, the territory of the Mississaugas of the Credit First Nation, who are direct descendants of the Mississaugas of the Credits. We recognize and deeply appreciate their historic connection to this land. We also recognize the contributions of the Métis, Inuit, and other indigenous people. Recognize the contributions they have made both in shaping and strengthening this community in particular, and our province and country as a whole. I should indicate that the Q&A button is available for you to send in your questions, and questions will be addressed at the end. We are pleased and thankful that Dr. Flora Matheson, who is a sociologist, will be speaking to us today. You have details of Dr. Matheson's very summarized and condensed biography on the registration site, but she is a sociologist and the Endowed Chair in Homelessness, Housing, and Health. And she leads the Justice and Equity Lab at St. Michael's Hospital. As a sociologist, she implements and evaluates community-embedded solutions to reduce social and health inequities for people experiencing justice involvement, with a focus on people with brain injury. So we also have Dr. Arthur McLaughlin. He is a Senior Research Associate at MAP Center for Urban Health Solutions, St. Michael's Hospital, Toronto, a sociologist of the culture interaction, and his research focuses on the patterns of interaction that shape involvement, identity, and inequality. One of his current projects is a study exploring the challenges of community supervision conditions amongst people with a history of brain injury. So having done that, Flora Matheson, I will hand it over to you.
Thank you, Justice Barnes. Madison's going to pull up the slides for us today. Thank you, Madison. It's my pleasure to be here today and to speak to you about this topic. I'm going to jump right into my slides and into my talk, and start with a visual that shows the complex relationship between the criminal justice system and the mental health systems, and where they intersect. And I like to show this slide because people with brain injury often find themselves entwined in both of these systems. And these systems are incredibly challenging to navigate. You can see just by looking at these two systems, at all of the intersections between and within the two systems. And these are not all of the systems that people need to navigate. They may need to access the housing and the shelter system, the health system, the social service system, and the education system, and so on. So having one's needs met in these systems is complicated and challenging. And it becomes even more challenging for people who have traumatic brain injury. And if you heard Joe speak at the first training, he mentioned the sheer prevalence of traumatic brain injury in the criminal justice system, which ranges from 30% to 88%. So in reality, the majority of people who are justice involved have a history of traumatic brain injury, and you see these people in your courtroom. We also know that this injury is underdiagnosed medically in this population. And reasons for underdiagnosis and underreporting include that people don't seek care. It's hard to get medical assessment here in Canada to determine a diagnosis, even of TBI, even when you seek care. And there are long wait lists for assessment and for treatment. So let me turn now to the research we've been doing here in Ontario on traumatic brain injury and complex needs among people who are justice involved. One of our papers focused on men and women 3 years prior to their first federal sentence. This slide shows the prevalence of social and health needs among pre-incarcerated women 3 years prior to their first federal sentence, compared to a matched general population group. The data is based on a federal sample of men and women who were linked to medical records at ICES. And ICES houses all of the medical records of all Ontario residents, so you and me, with valid OHIP numbers. So what you're seeing are diagnoses of these health concerns. You can see very high rates of mental illness and substance use and injuries relative to the matched general population sample of women. 40% of pre-incarceration women have a diagnosis of depression, 47% have a diagnosis of drug use, and these percentages are much higher than in the comparison group. Now, if I show you the same rates among men, you'll see that these health concerns are also higher for the pre-incarceration men than in the comparison group. So what does this mean? It means that we're incarcerating people with considerable complex health needs in our prisons. And these prisons are not set up to address these types of health needs. You'll also see that I've isolated traumatic brain injury on both slides. Let's look at the women. The rate is about 10% and is about 11% for men. So lower than the 88% we saw in the earlier slide, but still much higher than what's diagnosed in the general population. Now, one other statistic you might have noticed on these two slides is the percentage of people living in neighborhoods marked by high material deprivation. It's at the bottom of the slide, each of these slides, or marked by poverty. And because we matched by the general population to the pre-incarceration sample on that particular variable, they also have the same percentage of their sample living in high material poverty neighborhoods. Now, let's look at the prevalence of similar social and health needs among a provincial sample of men and trans men. These are men who were released from the Toronto South Detention Centre. Again, we see very high rates of complex needs, higher prevalence of some than in the federal sample. For example, the prevalence of mental illness is 61%, substance use is 85%, and assault is 43%. Again, their information was linked to ICES medical records. So these are medical diagnoses. Here, we're also able to look at homelessness, and its prevalence is 42%. And 60% are living in neighborhoods marked by poverty, so even higher than in the federal sample. In the sidebar, we see that 26% had a diagnosis of traumatic brain injury, so 2 times the rate for the federal sample. So there seems to be higher rates of complex needs among this particular sample. Now, I want to talk a little bit about their healthcare utilization from both of these papers. For the federal sample, this is the pre-incarceration sample, we see higher average rates of visits for both men and women relative to their general population comparison groups. For all 3 types of visits, so emergency department, psychiatry, and family doctors, 3 years prior to their first federal sentence relative to the general population group. This suggests that they used a variety of methods and avenues to get their healthcare needs met. And we saw that they have considerable healthcare needs. When we explored health service use for the men and the trans men in the provincial sample, we found they had 3 times greater risk of emergency department visits in the 3 months post-release from the Toronto South Detention Centre relative to their matched general population group. So what does this mean? We concluded that EDs were essentially acting as de facto walk-in clinics for these men, possibly in lieu of access to primary care. So now I want to talk to you about a couple of papers where we focus specifically on traumatic brain injury In the first paper, we identified a cohort of 1.4 million young adults, so age 18 to 28-year-olds, in 1997 to identify their history of traumatic brain injury from diagnostic codes, again in the ICES medical records, and their history of incarceration from the Correctional Service of Canada Offender Management Database, which was linked to the ICES data. The primary outcome was risk of federal incarceration from 1998 to 2011. Our primary finding was that young adults in Ontario, age 18 to 28, with a history of traumatic brain injury were 2.5 times more likely to be federally incarcerated than young adults without TBI, so almost 3 times more likely to be incarcerated. In a follow-up study using the same linked data, we looked at a cohort of adults between 18 and over, experiencing their first federal sentence between 1998 and 2011. We looked at serious in-prison disciplinary charges that were incurred 2 years post-sentence commencement. TBI was based, again, on diagnostic codes, and we wanted to understand that association between traumatic brain injury and disciplinary charges. What did we find in our results? So 13% of this sample had a diagnosis of traumatic brain injury. A third of the sample with recent TBI had a serious disciplinary charge. 40% of the men had with a TBI had a serious disciplinary charge. 30% of the women with a TBI had a serious disciplinary charge. And those with TBI were 14 times greater risk of incurring a serious in-prison disciplinary charge than those without TBI, so 14 times greater risk. So some of the takeaways from these two studies suggest that TBI is a risk factor for incarceration, especially for young adults, and that having a TBI makes it difficult for people to adapt within the prison environment, which is not equipped to support people who are differently abled. We also know there are few to no interventions and accommodations for ABI and TBI in prison and in jail. So now that we've provided an overview of the prevalence of TBI and these complex needs and how they kind of intersect, Arthur is going to take you through some of the challenges of community supervision for people with brain injury. Over to you, Arthur.
Thank you, Flora. And in providing that overview of the complex health and social needs, prior to incarceration, during custody, and yes, indeed, upon release and reentry, you've really set up the focus of my talk, which is focused on the challenges of community supervision. I'm going to provide a bit of a dive into the preliminary findings of the Catch-22 study, which is a qualitative study that seeks to better understand how people with a history of brain injury experience community supervision and conditions of relief. We'll get a little bit of feedback, maybe if you mute Flora. That's better. So how people with a history of brain injury experience conditions and community supervision, as well as how people who work in the justice system set, monitor, and enforce conditions in practice. Today, I'm going to highlight some of the challenges of conditions for folks with a history of brain injury, as well as some strategies to better support people with brain injury through the justice process. Some of the examples are going to be specific to the court, while others are going to be specific to the community. In either case, I want you to try to think about how they might apply in your own work as judges and justices, and what you might be able to learn, adapt, and apply in your own context. Okay, so the first theme is around receiving and understanding conditions. Participants stress that the challenges of conditions begin early on in the process, as they're working their way through the courts, and indeed when conditions are first set. Multiple participants stress that the court process was something that they felt quite detached from, that the emphasis and their focus the pressing priority was just signing whatever they needed to sign, agree to whatever conditions they needed to agree to in order to just get released and figure it out later. So as one participant noted, I was happy to be signing the paper and getting out of jail. More times than not, when we're signing the papers, we're just about to be released. So our minds are more focused on seeing them later, right? So agreeing and then figuring it out what they actually mean in their context later. A number of participants noted that while the court process was often brief, it could be difficult to follow. The legal language of the court, as Joe noted in our first session, could be difficult for individuals with brain injury to understand, and the court orders, the language of court orders as well. So for example, 9 times out of 10, it just looks like words. It's all written in, you know, it looks like mumbo jumbo. You can't understand it. So what are some of the challenges of conditions that people experience in community? Well, challenges with compliance often revolve around limitations in the ability to self-regulate and limitations in cognitive communication. Recall in session 1, Joe provided an overview of traumatic brain injury and its associated challenges, which occur in 4 primary domains. You have challenges with cognition, communication, behavioral regulation, and emotional regulation. These challenges not only limit individuals' abilities to participate in the court process and comprehend the court process, but also can limit their ability to comply with conditions in the community. For example, a defense lawyer told us clients with brain injuries have such mood swings that for them to control their behavior is much more difficult. And so their ability to follow conditions is much more difficult. They don't have the capacity to make what you and I would do in an executive function. Some conditions were more challenging than others, participants noted. The most common one was mandatory appointments. Navigating to and from appointments could be a challenge in the context of a brain injury. And one participant described an example of the stress and anxiety that she would experience in navigating a new city and attending unpredictable urinalysis testing. I have severe anxiety and stuff, and I'm in a new city, and it's huge. When they would call me in to say, you have to come in now to do a pee test or whatever, I mean, I don't have anything to hide, but it was stressful for me, and I would sometimes break down. They weren't like adapted to be very inclusive when it comes to that kind of stuff. I managed, but you know what I mean? It's still very, very difficult, almost impossible sometimes. Remembering appointments was another challenge frequently raised by participants. And memory challenges could be connected explicitly to their history of head injury. For example, my memory isn't good at all. A lot of that has to do with the head injury as well, remembering appointments and stuff. I couldn't remember. These health-related challenges could contribute to breaches of conditions and result in further criminal consequences. A defense lawyer told us, a lot of my clients have problems just getting to their probation appointments and remembering them. And if you forget one and you don't show up, then you get charged with a breach of probation and you're back into criminal court. Unfortunately, you know, it's a tough one for a lot of clients. So in the context of these challenges, multiple participants felt as though they were being set up to fail by a system, by supervision officers, by a number of players along the line as they move their way through the justice process. For example, one participant described the challenges she experienced with her parole officer and a particular condition that was difficult for her to respond to in the context of her disability. That special condition that they have on everything that says, do anything your parole officer says, was particularly challenging. That one really, really got to me because I'm supposed to have everything written down. a list of things is easier for me to understand. If it's not written down, how the heck am I supposed to remember all this stuff? It just didn't make any sense, especially for someone who has a disability. It feels like the world is made for people who are neurotypical, not neurodivergent. So it made me feel like sometimes things were impossible and that it was set up for failure. So how might individuals working in the justice system, working with people with brain injury in the justice system, better accommodate and be more responsive to brain injury in the justice process? I'm going to share a few examples in what follows. And you might be already immersed in some of these, and others you might want to consider applying in your own work to the extent that you're able to on the bench. Again, in our first session, Joe emphasized the great kind of cognitive demands and resources that people with brain injury are operating often in the context of more constrained, circumscribed cognitive communication resources. So whatever we can do to reduce the demands on those resources can help facilitate their inclusion, communication, and comprehension of the process. A justice of the peace told us that using plain language was a strategy, could be a strategy that you apply. If you're a cop or a justice of the peace, you're using terminology and somebody else will have no idea what you're talking about. And that's something you got to be careful about when you're presiding in court. I would try to explain in plain language when I realized that a lot of jargon was going back and forth, such as primary ground, secondary ground, tertiary ground. So you got to, explain to them, okay, here's the deal. This primary ground means you're going to show up for court, and so on. Another strategy is to slow down the pace, assess the level of understanding of the person in front of you, and seek additional support if needed. For example, once you've realized and established the fact that the cognitive factor in this individual is not there, then you better back it down to be able to at least establish in your mind that they are understanding. You as the presiding judicial officer could go, whoa, hold on a minute. There needs to be some sort of assessment done here. Multiple participants stressed, to the extent that the judicial process can accommodate this, that their consultation or at least some participation in the setting of conditions would make them more achievable in the context of their health and social needs. For example, one participant said, you can tell anybody to jump 10 feet. It doesn't mean everybody can jump 10 feet, right? A justice of the peace noted that being more responsive to brain injury may require moving beyond, in the setting of conditions, moving beyond boilerplate release orders to more targeted approaches. For example, what happens is you get into the trap of the standard boilerplate. Well, this condition fits, so let's just throw that one on there. The next thing you know, they're back the next morning in bail court because you put some dopey condition on there that's humanly impossible to comply with because they got a brain injury. They just don't comprehend. So what does this look like in practice in terms of setting conditions? Well, the same justice of the peace provided the example of place-related, boundary-related restrictions and really digging into the details thereof to assess whether they would be achievable in the context of a brain injury. For example, if an order of the court is to reside at a certain place, stay away from this place, you got to sort of really think about it. Crown will say 100 meters away from 50 Smith Avenue. Well, hold on a second. The individual has got a brain injury. Most people don't know what 100 meters is. Focus in on the detail so that you're not creating a potential for another breach, and I guess creating a potential for failure. Part of being more responsive to brain injury in community supervision is to be more aware of some of the everyday challenges of dealing with brain injury and what that looks like in people's everyday lives while under conditions. And to take that health-informed lens in the setting, monitoring, and enforcing of conditions, and especially attending to skill versus will in the compliance process. For example, someone with a history of brain injury and a history of conditions said, let's say that a client is MIA, missing in action. They didn't meet their appointment. That does not necessarily mean that they're purposely missing their appointments. It's not purposely because they're lazy and don't want to go and want to be jerks and get breaches. It's just, it's overall, it's a brain injury. It's a condition. Look at other factors, you know, as to why that happened. And if they all meet that criteria, that it falls under a brain injury, as opposed to being careless and lazy. So the challenges of brain injury can present challenges for compliance. In the context of those challenges, compliance, as noted by a number of participants, successful compliance is often a community effort, enlisting and involving a range of players and providers to support compliance in the community. For example, a bail program manager shared some of the strategies that staff use to support people with brain injury through the bail supervision process. Some people that just generally have a hard time with compliance, not because they don't want to comply, but just because they don't have the capacity to comply. If they need maps, make sure that you give them maps. Make sure that you give them directions. Make sure that you give them a lot of written material. Make sure that you give them phone numbers if they need to call. If you can establish that rapport with them, then they might be confused, but they're going to be comfortable to call you when they're confused. The point I want to emphasize and leave you with this example is that if you're seeing individuals for breach of conditions and they have a history of brain injury in your court, part of the breaching process can be connected to and a result of not having the adequate supports, community resources and supports in place to support compliance in the effort. The often successful compliance is contingent on these networks of others who are facilitating compliance throughout the term of supervision. So those are some of the experiences, challenges, and strategies we have been hearing from individuals with lived experience of brain injury and conditions, as well as individuals who work with people with brain injury in the justice system. This study, the Catch-22 study, is ongoing, and we are looking to add the perspectives of justices and judges to better understand how you approach setting conditions and responding to breaches in practice. It's a qualitative study. Participation is anonymous. All identifying information is reviewed in this process. And so far, we've interviewed one justice. You've seen some examples from that interview. And that interview was so helpful in helping us to better understand the intersection of your work with the trajectory of people moving through the justice system with respect to conditions and community supervision. After today's session, Justice Barnes will send out in the coming days more information about the study and how you can get in touch with us and learn more and participate. I now turn it back to Flora to discuss some practical resources you might be able to use to support folks with brain injury in the justice system.
Thank you, Arthur. That was great. All those concrete kind of examples of how to support people with brain injury. Appreciate it. I just want to leave you with some resources that might be helpful for you. The first thing I want to talk about is the communication intermediaries. I'm not sure if you're aware of these, but so we thought we might bring these forward to you. These are registered speech language pathologists who are trained to facilitate two-way communication between justice professionals and individuals with either speech language and cognitive communication disabilities, They provide accommodations needed for individuals with these disabilities so they can participate fully in legal proceedings. They do not play the role of witness, advisor, advocate, mediator, personal attendant, or other similar roles. And the end user, such as the police, the RCMP, Crown Counsel, Defense Counsel, is responsible for the cost of CIs. They are impartial and neutral parties at all times, and they assist the person to understand questions posed to them, for example, by a police officer, lawyer, or court official. And the goal is to help the person who needs accommodation to communicate their responses to the police and court, or to understand the evidence. And the CI doesn't coach the person how to respond or provide legal or procedural information. They also don't comment, advise, give expert opinion on a person's competence to give evidence, or express expert opinion on the truth or reliability of what a person has communicated. So I think I want to show you this video, and Madison's going to bring it up, with Caitlin Bushell. She's the Executive Director of Communication Access to Justice, and this will show you really well what CIs do. And I think it will be really helpful for you to understand what the role of the CI is. So we'll just watch this. It is very short, it's less than 3 minutes.
TNT, sisters and children to
A communication intermediary is someone who works pretty much exclusively in the justice system. A CI acts as a neutral, unbiased intermediary to facilitate two-way communication between police, defense counsel, a judge, and an individual with a communication disability who needs to have some kind of involvement with the justice system.
And so you have the babies.
Those 2
girls.
Yeah.
Okay.
Yeah.
To see what people suffer through, and knowing that often the people that I've been involved with, like, this is not their first trauma. You know, this is the 5th or 6th. And so I step back and I remember, like, listen, I'm just sort of an observer. But there are times where if they break down crying over a description of a sexual assault, I'm not there to give them a hug or make them feel better. That's hard. What I remind myself is that, you know, because of communication intermediaries, this person can tell their story. At the end of the day, you know, we all just want to tell our stories.
Nibby is
Okay,
because way back, did you speak Ojibwe?
no, just this is the babies.
The babies, yeah.
When we look at both the victim population and, unfortunately, the incarcerated and accused population, there are huge numbers of individuals with language disorders and delays. When people talk, there's often a lack of understanding that they might still have a communication disability. So if I can say words and you know what those words are, people assume that, okay, well, you're fine, you can talk.
Renee, do you want to write your name?
We know, you know, if you see someone, let's say in a wheelchair, and you see a set of stairs, you as a person without a physical disability can appreciate that, okay, that's not going to work. With a communication disability, it can absolutely be invisible. The challenge here is that, you know, communication disability, which is what's causing their challenges in the justice system, also affects their ability to get out there and advocate when they're not provided with the accommodations that they need to do so. If, you know, the work that a CI does can allow that person to tell their story and have others, and not just anyone, but the people who can make a difference, if you can have them hear it in a way that they understand, then, I mean, how can you not do that work?
Thank you, Madison. That's great. Sorry, I apologize. My camera was off when I was speaking earlier. So I hope that video was informative. I know it was for me when I first watched it. And I've met Caitlin, and she's amazing. So yeah, I hope you take a look a little more deeply at the communication intermediaries. And if you do want to engage a communication intermediary, there are some steps here that we've included in the slide deck. I won't go through them in detail, but it does walk you through what the steps are to engage an intermediary. And if we move to the next slide, Madison, this slide gives you information on how to access the CIs by contacting them directly or through the court accessibility officers. And then I also want to point out a few other resources that we thought might be useful. The Abuse and Brain Injury Toolkit has information on the intersection of intimate partner violence, which we know is a huge issue in the criminal justice system, and traumatic brain injury. And we know that traumatic brain injury is a huge issue among women who are survivors of intimate partner violence. The ABI Justice is a Ontario porthole for legal information related to people who've sustained a TBI and or those who assist clients who live with brain injury. So it provides a lot of information for both parties. And the provincial acquired brain injury navigators provide a navigational link between the healthcare system and individuals with acquired brain injury, including traumatic brain injury, to improve access and capacity and improve outcomes. And many of these acquired brain injury navigators do work with people with criminal justice background who have traumatic brain injury or acquired brain injury. That's not their overall mandate, but they do see many people in the criminal justice system. And then finally, the Justice app was created by the Community Networks of Specialized Care, and their mandate is to provide coordination to adults with developmental disabilities. And the app is a web-based app, and it provides a general overview of the criminal justice system for both clients and providers. And then I want to end with just a thanks to our funders for their monetary support for our research and training initiatives. And then we always feel immense gratitude to our community partners and people with lived experience who collaborate with our Breaking the Cycle Solutions Network, and to our many participants who have contributed to our knowledge and our research that we've been able to share today. The quality of our research and solutions we develop is a testament to their engagement and expertise, and we couldn't do this without them. And so we want to thank them as well. And thank you for your attention today, and we hope this was useful and helpful to you. And we can open up the floor for discussion now. Thank you.
Okay, there is a question. In a busy courthouse where people are cycling through quickly, what strategies can be used to identify whether a person has ABI?
I think one of the ways would be to, how would I say this? I think now having some of the groundwork, knowing some of the ways you might, like knowing now what you know about traumatic brain injury, that many of the clients that you may see in the courtroom will have a traumatic brain injury, that and just being aware that they're I'm not sure what to say here. There are ways to, go ahead, Arthur.
You can finish your thought if you, yeah.
I'm stumbling a bit here.
Well, it is a straightforward, but also kind of complex process. I would go back to immediately, I kind of thought of just as compliance can be this community effort enlisted, like it's not all on the justices and judges who often have very short amount of time with individuals moving through the court, but to the extent that counsel, duty counsel, criminal defense lawyers, crowns are participating in this brain injury awareness education training, then that sort of identification, what I wanted to say, my little snippy little thing was like, identification is also a community effort, right? And so if defense counsel, there are screeners you can use, right? And there are resources in the community that can also assist them to do this quite quickly. There's a bit of 5. There's the help screener, for example, and it's probably in the list of resources that we link to, that just goes through a set of 5 questions, and you answer to a number of them in the affirmative, and you're likely to have a history of brain injury. And if that's the case, and indeed, the prevalence studies seem to suggest that at least half, if not upwards of 80% of the people you are seeing going through the system will have a brain injury. So assuming that they do, and responding to be more inclusive in general, may allow you to kind of circumvent whether to try to have to put the pressure on identifying or not, right?
Okay. Are there any other questions before we wrap up? We've got a few more minutes. Well, it appears, I'm not seeing anything else in the Q&A. It appears that your presentation was so clear that nobody has any questions. One question I have is that if somebody were to show up and it's, people kind of have ABI and look quite normal, and if I ask them, do you understand it, they say yes, what am I supposed to do? I mean, like, how, I'm looking for, I guess what you are saying is that we should sometimes slow down things a bit, or should we be asking, counsel whether or not they've explored that with their client? That seems to be a bit too much. So I'm sitting on a bench and people are going very quickly. It looks like I'm looking for more guidance. Or I don't know if somebody else has a comment. I'm trying to see if I can get somebody else to comment. It's been a long time since I had to actually work with people at a very quick pace. So I may be.
This reminds me of, and I'm going to enlist Joe and, well, anyone else who wants to jump in here, but this reminds me of in session 1, Joe noted that part of it is a shift away from these yes, no binary sort of responses, which again, people coming out in the qualitative data, and we've heard this anecdotally as well, there's a great deal of pressure from the point of arrest on through to just say yes, 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 to do it, say yes, so that you can be released. So instead of asking, do you understand? How did you put it, Joe? It's asking these open-ended questions to assess the level of understanding. So what do you understand? What was just put before you? And get them to say it back to you, their level of understanding or comprehension.
Okay, so you're more or less saying that we should just try and keep it as simple as possible.
Simple as possible, but ask, like, involve them in the, like, try to not ask them yes or no questions, like, to the extent if you want to assess understanding. Joe, jump in here and save my butchered response if you want. I think you're muted. You're muted.
You're muted. Yeah. I mean, I think one of the ways while Joe is getting oriented there is that to ensure that they understand the decision, like not just a yes or no, but ask them maybe to reiterate the decision, like that they actually do understand it, rather than say, do you understand the decision, or do you understand what you're supposed to do? And they say yes or no. The yes or no, they may not actually understand it, but they may say, yes, I do. But to get a little bit more of a response for them, so that you get an understanding, so that you actually you actually know that they understand. So it's more actually kind of pulling out some information from them, so that you actually do get a clear message that they understand what they are supposed to do, rather than a yes, no response. I think that's what Joe had said in the first training session.
Yeah. Can you guys hear me now?
Yes. Yeah.
Okay, super. Yeah, and I just want to add to that I think it's really important to understand, as legal actors, to the best of your knowledge, the conditions or the parameters under which somebody can understand something. And I think the example Arthur talked about of the participant who said, if stuff's written down, I have a much easier time understanding things. But if I have to do it verbally, like my understanding just collapses. There's like a really clear example where you can see the mechanistic cause of a brain injury, which is reducing the maybe baseline level of cognitive communication resources, if you want to think of it like that, versus like the parametric effects of the environment, i.e. the way in which the information is presented, whether verbally or in a written form. So I sympathize with any legal actor because these are very difficult problems to have to try to troubleshoot in a legal context. But unfortunately, the message that we have to give you as scientists and researchers is that like it really is a matter and a question of trying to control for both these mechanistic causes, i.e. the injury itself, and then these parametric causes, i.e. the like overall social communicative context in which these people are navigating and having to interact with bail conditions.
I can give you an example of something that Arthur and I saw. We were sitting at bail court, and a gentleman was standing in front of the judge, and the judge was talking to this person and said, and I could tell that the person was having there was a communication challenge for the person. And the judge is saying, well, we're going to give you a piece of paper, and then you have to take that piece of paper and you have to go here first and take that paper like to this floor in the bail. This is downtown, the new bail court. You have to take it there, and then you have to go to this floor, and then you have to go to this floor, and then this floor. I lost track myself, and it wasn't written down for him. And I know that by the time he left that courtroom, he had no idea where to go and what to do. And I think I feel he had a communication problem, but I also feel there was a language barrier as well, in terms of first language. And so he was at a loss at the end and also at a disadvantage. And so if he had had something written down like that, he could take away with him and say, here are the steps that you need to do when you leave this courtroom so that you know where to go. And this, you have to go to floor 17. This is who you're going to see, and this is why you need to see them. After that, you need to go to floor 3. This is who you need to see, and this is why you need to see them. Like, what's the process for that person? So sometimes you need like a recipe. That's sometimes helpful. And I know that's a lot of work, but sometimes people need that in order to be able to fulfill what they need to fulfill in the legal process.
You know, we have two questions. I'm just sort of going to link them somehow. Maybe you could address them. The first had to do with the communication intermediary, right? And the question was wondering how that's going to work in the virtual court, because a lot of bail hearings are virtual. I stand to be corrected, by the way, because I do not know what I'm talking about. But a lot of bail, some appearances are virtual. And how do you use a communication intermediary in that environment? And just to confuse you before you even think about that question, I'm going to throw in something else. So whilst you're resolving that issue, you just told us to use plain language. And there's been a question here asking, well, you know, are there any resources that can help with plain language terminology for justice participants? So the first one is more difficult, but I don't know. I'll leave it to you.
The virtual piece around, I haven't talked to Caitlin about how she works virtually with her communication intermediaries. I don't know, Arthur, you saw her presentation. I'm not sure if she spoke to that, but she's very accessible. So, I mean, that would be just a reach out to her. We can come back to you with that and I can ask her about that and send you information, Justice Barnes.
Okay.
Yeah. And what she did say, like if you want to understand the role and function of a communication intermediary, just think interpreter, translator. same sort, they would be involved in the same sort of process at the same points. I would imagine that depending on the person's disability and the assessment, there may be, that person may be appearing in person if in person is an in-person interaction is what's required to facilitate communication with that person. So they get involved early on in the process, and you may not even be seeing people virtually if virtual doesn't work for them. Or if it does, the communication intermediary might be with the person in person to transmit virtually. But she would know, Caitlin would know. Any plain language resources for justice participants? I mean, I don't know of any that are specific to the justice process. I'm not sure if you do, Joe. I know there is, I know Flora, you know that there's plain language training in general and strategies, techniques, tips to move from the recognizing jargon, recognizing esoteric language, and translating it in more plain language terms. The one justice of the peace provided in an entertaining example, like, who the hell uses tertiary anyway? I'll tell you who, we do. Well, that's it. So I took his point, but I'm not sure that there was any specific training for justices. Joe, do you know of any?
Yeah, there's a resource in the States. It's called plainlanguage.gov. I'll put a link in it, but they've got kind of a bullet point checklist and just a general summary of how the plain language movement kind of operates and how it works. It focuses, I will say, mostly on written language. So again, it's kind of a limitation for spoken language. But spoken language does tend to be less complex than written language anyway. But I'll put that link up in just a second.
Justice Barnes, was that specifically for like related to justice language? The question?
Well, it says language for justice participants. So I assume that anything to do with justice participants will be helpful. I mean, when people are going through the court system, they don't always. It's not always going to simply be legal language, right? I expect you want some plainness with respect to legal language, but there will be some things about day-to-day activity, right? So
Right.
I'm telling somebody that they have to attend that courtroom at on the third floor to do something. Maybe the use of the word attend may be a bit weird. I don't know. I mean, it's just an example.
Right. I know that many of our community partners have made justice documents into plainer language for their clients when they're working with their clients. And even some of the conditions of release documents they've made into plainer language. So I just wanted to put that out there so that people are aware of that. So there are community agencies that work with clients in the criminal justice system that do translate legal documents into more plain language for their clients.
Right.
Yeah.
Okay. All right. Joe has what do you call it? Put in a link. I do not know if everybody can see the link in the Q&A. Joe, can you put it in the chat just in case people cannot see the Q&A? Not exactly sure everybody can see the Q&A. It looks like we are wrapping up. Any last comments from Arthur, Joe, or Flora?
I'll toss one out there. It just came to mind as Flora was talking about our partners in plain language. Dr. Catherine Wiseman-Hakes is at McMaster University. She's a speech language pathologist. Joe, you've worked with her as well. She has a website, tbiyouthjustice.org, and there are some plain language descriptions of the justice process from arrest all the way through sentencing that are there as well.
Okay.
And that was one of the resources I mentioned in my first talk. So if anyone wants to find that directly, it'll be in my PowerPoints. Yeah. Thank you, Arthur.
And then it looks like we have a comment. Can the association advocate for there to be a communication intermediary on site daily who may be called into courtrooms as needed to help assist those navigate where they need to go. An example of several locations, that is, understand conditions, etc. And the comment says some cities have community mental health workers on site, and I guess the thought is that communication intermediaries could also be on site and play similar roles, at least with respect to people with ABIs. So that's an interesting idea to be looked at. What do you guys think about the suggestion?
So we're working on a Justice Brain Injury Navigator program. We're developing that. We just got a little bit of funding to try to start that program. We're looking for other funding, and it would be a brain injury navigator that could work at the courts. They could work at community agencies to support people with brain injury, either coming out of the institutions or in the court system to help them navigate the justice processes, but also the health system and things like that. I'm happy to share that at some point in time if people are interested, what we're trying to do with that program and that navigator role. So it could be something like this as well. That navigator could play a role like this. I think the communication intermediaries are different in the sense that they are more hands-off and they're more like an accommodation it's more to help with accommodation. But I do agree that this is something that would be really important. And it's something that we've been working together with the Breaking the Cycle Solutions Network to try to build a navigator for brain injury, for people with brain injury in the system, to support them.
And I would just add to that another plug for the Catch-22 study, which is that qualitative study, which is informing the shape of that navigator program, right? And where it might be situated and how it might function. So again, a call for participation, whether you feel as though you are at the leading edge of including people with brain injury or not in the justice process, learning about the pinch points, the pain points, the challenges of your own work in trying to identify people with brain injury and accommodate them, the lack of resources, the lack of time that you have to do it. That's all very interesting stuff for us to learn about. Again, anonymous, your participation would be, you'd be de-identified. So happy to have you contribute to the shape of that program vis-a-vis the Catch-22 study.
Right.
But Justice Barnes, I'm happy to introduce you to Caitlin.
Yes, yes, no, certainly that'd be great. I mean, to give us another avenue to make sure that we all learn something new. So that'd be great.
Yeah.
I'm always interested. Well, Arthur, Joe, and Flora, I take it there are no other comments. This has been an informative presentation and also discussion. It is a challenge for those of us who work in the criminal justice system. So we appreciate what you've been able to impart today. And so we'll say thank you. We continue to work with people like you as we try to bring such programs to bear to help us all continue to learn. So with that, thank you so much for giving up your time. And for everybody, thank you for taking the time to participate. We will send you a recording of today's proceedings, and feel free to contact Arthur, Joe, or Flora if you need any more information, or you want to hear about the survey, or whatever you want to do, you could contact them, and I'm sure they'll be happy to help. So with that, have a good afternoon and many thanks.
All right. Thank you.
Okay.
Thank you. Bye-bye.